Hey everyone, welcome back to the Irretrievable Breakdown podcast where we discuss all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and I am joined by the managing partner of our firm, Nicole Bikakis. And you can catch our show on YouTube, or you can subscribe on Apple Podcasts or Spotify if you want to catch us on the go. Now, today we are going to discuss just a 1,000-foot view summary of what the divorce process looks like here in Connecticut, sort of from beginning to end. We're not going to get into too many of the details, as we've created separate, podcast episodes about the nitty-gritty details of each area of divorce, but we are going to give an overall summary. But before we get into that, Nicole, why don't you tell me, how your day's going so far? How was your weekend? All that good stuff.
Weekend was great. I feel like this was one of the best weather weekends we've had this
Yep.
summer. Got to go to the beach, which is really nice, right by you, frankly.
Yep. A little Milford Beach action for you.
It was really nice.
Yeah.
Hadn't done it yet this summer, and it was awesome.
Nice. And sadly, we have rain coming. We have our firm summer outing coming up on Thursday. And, it's where everybody from our office, their families, their kids come. And it's at a beach club here in Connecticut. And it looks like it's going to rain. So we'll
I
have
was
to.
really relying on some good weather for this venue. But we'll make the most of it. I'm
Yep.
sure we'll still have fun, but I'm still going to maybe hope and pray that the weather pivots.
Yes.
Get
We
some
hope
good
so.
weather. We'll see.
So, the divorce process. So let's start sort of before you even file what you need to be thinking about. Obviously, the main thing is deciding, do you actually want to get a divorce? Presumably, if you're watching this or listening to this, you've given it a lot of thought. But once you bring up divorce to your spouse, it can be hard to unring that bell and reel things back. So I think you generally want to try to explore all options if it does seem like your relationship is coming to an end, depending on your situation. Maybe you want to explore going to couples therapy, and that's a conversation you can have before actually saying you want a divorce. Something like, I'm unhappy and I feel like we have XYZ problem in our relationship, but I want to get help to see if we can make this work. But if you've gotten past that and you decide that, your relationship is not going to work and you need to get a divorce, then, there's a number of preliminary things you can do before you actually file. One would be to gather any financial information you can for your family. It's important to have a general understanding of the finances. So if you suspect that your spouse may restrict access to that information after you file, it's best to get as much as you can in advance. And you should also have a consultation with a lawyer. A lot of law firms, including ours, will offer a free consultation. So having that financial information in hand for that meeting with the attorney is useful. It's not like if you can't gather financial information and you file for divorce and your spouse sort of cuts you off, it's not like you'll never be able to get that information. There are avenues to get financial information, but it's best to know as much as you can early on in the process.
Well, you'll just get a little bit more out of the consultation if you have more information for the attorney coming into it.
Exactly.
And I always like to say, even if you don't think you can afford an attorney for the divorce itself, doing an initial consultation, like you said, our firm provides free initial consultations, and there are other firms that do so as well. Other firms provide consultations for a fee, but it's worth it to just have that initial consultation to talk to a knowledgeable attorney about what the process looks like, even as you're kind of deciding for yourself if divorce is the right step. Having a conversation with an attorney doesn't mean you have to start the process, but you'll have a lot more information to go off of.
Right. And that conversation will be privileged, where the attorney, it won't It shouldn't get back to your spouse that you had that consultation. Now, if you are planning on filing for divorce before you actually file, another thing is just ensuring that you and your children are safe. If you have any safety concerns where you think your spouse is gonna like freak out and do something that will endanger you or threaten you, then you need to take precautions to deal with that. And, what those precautions are, there's a number of things that you can do. And we don't need to get into the details of those. But if you do have safety concerns, then definitely have a consultation with an attorney so you can share the specifics of your situation and get an understanding of what you can do to make sure you're protected if you are going to initiate a divorce.
And I do think we've had podcast episodes on this as well, but where you don't have safety concerns and you've decided that you want to proceed with a divorce, having that conversation with your spouse, the two of you together might be able to go do a consultation for a mediation if that's appropriate to really figure out all the different options that you have for getting divorced. And you can, you never know, you might be able to start off the divorce process like in step with your spouse and come up with a process that might work for both of you where you guys can deal with it as amicably as possible. That's not always the case, and many people do require their own attorney, but you could still do a consultation with an attorney, and then after that, explore mediation consultation with your spouse if that's appropriate for your circumstances. But all in all, to say, having a conversation with your spouse and not just jumping into a divorce without first giving them the courtesy of a conversation.
Right. Right. I think that's always good. And there are a number of different approaches, as Nicole mentioned. There's mediation, there's collaborative divorce, there's traditional litigation where you each have attorneys. You can be self-represented where you go through litigation self-represented. There are a number of approaches, but for the purposes of this conversation, we're not going to get into the details of mediation and collaborative divorce. This is just more the traditional route of going through the court process, whether you have attorneys or you are self-represented. So if you've had that initial consultation, you have decided, okay, I have the financial information that I'm going to gather at this point, and you just decide you want to start the process. So first you have to draft the paperwork and have your spouse served. If you're self-represented, you'll want to bring the paperwork to the courthouse and have them, they can help you with the paperwork, have them check to make sure it's filled out properly. And then before you file, you actually first have your spouse served, or they can do a waiver of service. If you tell them you're going to be filing, they can file a waiver where they don't have to be served. But if you do serve them, you'll have to find a marshal, and the court clerk's office can give you a list of marshals to have your spouse served. Or maybe you're watching this video and your spouse has filed for divorce and you are defending, and sort of, if you've received divorce paperwork, then you're going to want to consult with an attorney, and you're going to want to file an appearance if you're self-represented. As far as, it doesn't really matter if you're the plaintiff or the defendant, so I wouldn't get too freaked out about who files first and all of that stuff. The only thing that it impacts is if you have a trial, which you probably won't because most cases settle, the plaintiff gets to present their case first and the defendant goes second. And there's really no advantage or disadvantage to who goes first or second in a trial. So I wouldn't get too hung up on who is the plaintiff and who's the defendant.
Other than to say that if you are the defendant, just make sure that once you submit your appearance in the divorce after you've been served, so now you're going to file your own paperwork, you want to file what's called a cross complaint, because in the event that your spouse gets cold feet and decides to withdraw the divorce, if you want to proceed with a divorce and you want to have the option to decide whether you want to proceed or also withdraw, you need to have that cross complaint filed. Otherwise, the entire action gets withdrawn. So make sure, again, you're going to typically want to do at least a consultation with an attorney to know what you're up against, what the process is going to entail. And they would, of course, tell you to file a cross complaint because that preserves your right to proceed with a divorce if the filing spouse decides they don't want to proceed anymore.
Exactly. So with those initial filings, whether you're the plaintiff or you're thinking about filing it afterwards, if you're the defendant and you've been served, you may want to file what are called pendente lite motions. And those are motions seeking temporary court orders that are in place while the divorce is pending. So the most common pendente lite motions are a motion for alimony pendente lite, or child support pendente lite, or contribution to household expenses pendente lite. So those are motions seeking financial support from the other side while the divorce is pending. Obviously, that may be necessary if you are the person who does not have an income or who has a much lower income than the other party. Another, you may file a motion for custody pendente lite to get a parenting plan put in place while the divorce is pending, or maybe a motion for exclusive use of the house if you want to have your spouse removed from the house while the divorce is pending. Just side note, very difficult to, have that granted, having them removed from the house. It's not an easy thing. So just keep that in mind if you're filing it.
Yeah, those pendente lite motions really are filed in an effort to keep things status quo during the divorce process, and make sure that things that really need attention immediately that attention is able to be provided. And you don't want to spend too much time, arguing during the divorce on issues that ultimately you're going to have to resolve the divorce and deal with the finances and custody. But the pendente lite orders are really meant to put something in place if you feel like just the filing of the divorce action is going to create issues and tension, and maybe one person stops paying for certain expenses, or refuses to provide support, or doesn't allow access to the children. That's when those pendente lite orders are really important to try and, again, keep some kind of status quo in place while you work towards resolving the divorce.
Right. It essentially stabilizes things so that everybody can focus on the more long-term resolution of the case. One small thing, if you have children and somebody's filed for divorce, you have to do the parenting education program. It's just a course you have to take. It's pretty straightforward. So just make sure you don't. Sometimes that gets lost in the shuffle on actually doing the parenting education class. So just make sure you do that if you're involved in a divorce with children. So once all this stuff has been filed, what is generally the first court date? It's called a resolution plan date. And that's a date where both parties will go in and they will meet with the family relations office, a worker for the family relations office in the courthouse. Family relations, they're a neutral party who works in the court system to try to help people resolve their cases. They're primarily focused on custody, but in some respects, they deal with the finances also. So in that meeting with family relations, the worker will try to identify areas of agreement and disagreement. So try to understand, all right, what do these folks agree on? What do they not agree on? They'll then try to assess the likelihood of them reaching an agreement on the issues that they don't agree on, and what services will be necessary to try to help the parties reach an agreement. And based on those three assessments, they will put the case on either track A, B, or C. So track A is when the case is essentially fully resolved, when the parties already have an agreement on all issues in the case. Track B is when they have an agreement on some issues and no agreement on others, and they assess that there will really be sort of limited intervention necessary from the family relations office. And then track C is for the more highly contested cases where there's going to be significant intervention from family relations or other third parties, which will be necessary to help the parties resolve their case. So in that meeting with family relations, they will determine whether your case is track A, B, or C. And then after that, you generally go in front of a judge. Now, full disclosure, every courthouse is sort of different, and there's a lot of differences in how different courthouses handle the resolution plan date. Sometimes you won't go in front of a judge and they'll just give you your next court date. Other times you will go in front of a judge and the judge will kind of hear what the issues are and set a scheduling order and identify when your next court dates will be. Sometimes a judge will even have a hearing on that date for, things that need to be dealt with. So if there's like a pendente lite motion for alimony, sometimes the judge will say, all right, we're all here. Let's have a hearing and, everybody present evidence. And just to back up, in that meeting with family relations, you will try to resolve the pendente lite motions for alimony, child support. You'll see if you can reach an agreement on those issues. But if you can't, then it's possible that a judge will have a hearing on that day for the issue in dispute. It's more likely that they'll say, all right, sounds like you have a disagreement and you need to figure out this pendente lite alimony situation. Let me schedule this for a hearing on a future date. That is more likely, but be prepared to have a hearing because some judges will just have you go forward. And at the resolution plan date, if there are financial issues in dispute, which there essentially always are in not even in dispute. If there are any financial issues, which there always are in divorce cases, you need to have a financial affidavit. So bring with you to court a financial affidavit that is filled out. I've done a separate YouTube video on how to fill out a financial affidavit. So look for that video if you need help. And make sure you bring that to the resolution plan date with you. Nicole, I've been blabbing for quite a while about resolution plan dates. So what do you have to add, if anything?
Well, just to put it in perspective, the resolution plan date is happening about 30 to 60 days after the filing of the action. So it's early on. For some people, it's not, it doesn't come soon enough. And for other people, it comes really fast. The resolution plan date, you are supposed to have your financial affidavit done when you go. So when you're there on the resolution plan date, you each have a financial affidavit you can exchange. And that way, the Family Relations Office or the judge has that to look at and, if necessary, put in place these sort of temporary orders. But we see it all the time where people come in and they're not prepared with a financial affidavit. So sometimes a lot can happen at a resolution plan date. Other times, not a ton happens at a resolution plan date. And it's sort of that first step to determine. The court will tell you, okay, what are we shooting for here? Like what track are you going on? And like, what's the next step in your case? So it really varies in terms of what people can get done at that resolution plan date. And I always tell people, how quickly your divorce resolves really depends on your situation. If you have complicated finances, unlikely you're going to be able to resolve your case fully at that resolution plan date. But if you don't have complicated finances and you guys are all pretty much on board with what you're going to do with custody, it's possible people go into the resolution plan date and walk out divorced. That's also a possibility. But again, it really depends on your particular set of circumstances and what type of intervention is needed from the court. And then even where you don't need necessarily intervention, but you need to figure out the logistics, the financial affidavit and putting together an agreement. That takes time. You need to make sure it's done correctly. So in some cases, it's just not feasible to obviously resolve the entire divorce on the resolution plan date. But needless to say, it is the first day where you guys are actually entering court together. So it really kind of kicks off that court process.
Right. And as far as potential court intervention or non-court intervention, like what could get scheduled, if there's disagreements on custody, the Family Relations Office may schedule like a mediation where both parties, and not their lawyers, just both parties will come in and they will try to help the parties reach an agreement on custody. And that's both legal custody, so who makes decisions about the child or children, and physical custody, so what the parenting schedule looks like. Or if it's very clear that there's just not going to be an agreement and they realize that at the resolution plan date, then they may schedule a custody evaluation. So where Family Relations is essentially doing a custody evaluation and making recommendations about what should happen with regard to custody. And we've done other podcast episodes that talk about that. So, look at those if you want to learn more about custody evaluations. Or separate from a family relations custody evaluation, the parties may decide that they want to get a guardian ad litem involved who can understand the family dynamics and make recommendations about what should happen with regard to custody. So those are sort of the court interventions that, the court will probably also schedule a judicial pretrial potentially, and that's where a judge is trying to help the parties reach an agreement. Usually a judicial pretrial is more dealing with the finances of a divorce, and that is where, usually judicial pretrials only take place when there are lawyers involved in the case, and the judge will meet with the lawyers essentially as a mediation where the lawyers will make their pitch about what they think should happen with regard to, the divorce orders, and the judge will make a recommendation, and they're free to follow or ignore that recommendation. It's non-binding, but it's just an attempt to have the parties reach an agreement.
Yeah, I mean, the judicial pretrials happen off the record with the judge, and so the judge typically will only do them where there are attorneys involved, and the attorneys come into chambers and meet with the judge. And then in certain courts, the judge will then even present their recommendation to the parties, because sometimes the parties really just want to hear from the judge. But again, that in that situation, the judge there is only providing a recommendation, trying to settle the case. They could not then be the judge that deals with the case at trial if necessary down the road. So,
Right. It's a shame that that doesn't happen more often, because I think it's tremendously helpful when during a judicial pretrial, the parties get to actually hear from the judge. What's more common is the lawyers, will go meet with the judge. The judge will make a recommendation in a private meeting with the lawyers, and then the lawyers come back and tell their clients what the recommendation is. It's just less effective than hearing it directly from the judge. So I wish that more judges did the speaking directly to the clients. I find that
well,
very helpful.
and some courts they have what's called special masters set up. Again, two attorneys need to be involved in those cases, but a special masters involves the parties and their attorneys, and then two volunteer lawyers, one male, one female lawyer, who who is a who are family practitioners, who will sit down and basically hear again the same pitch from either side as to what they think should happen with division of assets and debts, alimony, custody, child support, the main issues that need to be resolved in the divorce. And then those special masters attorneys give their recommendation as to what a equitable resolution would be. And in those cases, it's very common for the special masters attorneys to then meet with the parties to really present their recommendations to them and speak to them directly about why they came to the recommendations they came to. And oftentimes those are also very useful tools to help parties get to a resolution.
Right. And to just back up a little bit, before these sort of negotiations around, particularly around finances, happen, whether it's in a judicial pretrial or a special masters, etc., the discovery process needs to happen. So that is when the lawyers are exchanging requests for disclosure and production. Usually you're asking for, a number of years of tax returns, bank account statements, credit card account statements, pay stubs, etc. It's essentially trying to get a full understanding of the financial circumstances of the parties. You'll want retirement account statements, because you need to verify what sort of makes up the pie that you are dividing from a financial standpoint. So that discovery process, it sort of runs separate and behind the scenes from the whole court process, where the lawyers will file a request for disclosure and production very early on in the case, usually before the resolution plan date. Then the opposing party has 60 days to reply and provide those documents. So usually that discovery is happening behind the scenes and outside of court, and you only end up in court with the discovery process if there's a dispute as to whether or not a certain document should be provided. So sometimes a lawyer may object because it's just overly burdensome. Maybe they're asking for too many years of financial account statements or some other document that seems completely irrelevant. But absent having to come into court for a discovery dispute, that process happens behind the scenes. And then once the discovery process is completed, that is really when these judicial pretrials and special masters pretrials happen. And of course, separate from that, those actual court processes of formal meetings, there's a lot of oftentimes behind the scenes negotiations between the lawyers where, somebody may send an initial proposal, the other side, gives a reply to see if you can sort of resolve the case outside of court. That's ideal when the lawyers can sort of communicate directly with one another and try to resolve their case. But it's just sometimes lawyers are just non-responsive and they don't do anything unless they have to go into court. So it really depends on the lawyers who are involved, whether or not the case can be resolved without any court intervention.
And the discovery timeline, it really depends on what the case, what the finances in the particular case entail. So you can have a complicated financial picture that requires business valuations or different experts to provide earning capacity reports. Your financial circumstances and like how complicated they are will determine how much time needs to be devoted to discovery.
Right. You
And
might need appraisals on real estate, things like that.
right. And you can't really get into negotiations. You can't get into even behind the scenes negotiations and proposals or pretrials or anything like that until you have really resolved that discovery phase and you at least understand overall what are the assets, what are the debts, what are the values for all these things. And then with some certainty that you have a picture and you have general numbers to make a proposal with and just to determine what is an equitable division based on these numbers. And again, in certain circumstances, you may in fact make a proposal to try and avoid spending a lot of money on experts. Sometimes values, that that something might be valued around a certain amount, but you don't have like a particular number, but you might decide to make the decision, I'm not going to spend the time and money getting the precise value. I just want to make a proposal, and you kind of take a risk on like what the value is. Again, you can make that determination or decision depending on the specific facts of your case, but it's so important to take the discovery phase seriously and follow it through. Just make sure you have all the information you need and don't, rush to get the proposal or settlement done before you're comfortable with your understanding of what the financial picture is.
Right. Right. Yeah, I think that's good advice. And then finally, if through all these settlement meetings you can't reach an agreement, you just have to have a trial where, you'll go in front of a judge and both, it's sort of like you see on TV. There's no jury in divorce court. So I guess it's different than TV in that respect, but you are presenting to a judge, your evidence. You have testimony where both parties will testify about the cause of the breakdown of the marriage, what the financial circumstances are, what they think should happen with regard to their proposed orders. Both sides will present evidence, present witnesses if they feel it's appropriate to do so, and a judge will make a decision, and that decision is binding. And that's the end of the case. Separate for, then after that, it's potential to appeal the case, but we're not going to get into that. We don't do appellate work at our office. The general finish point is a trial. Unless you reach an agreement, then you just draft the agreement and you submit it to the court, and that becomes your divorce order. But if you don't reach that agreement, you have that trial where a judge is making a decision, and that decision is binding.
And then even when you submit an agreement to the court does review that agreement, and the court has to find that it's fair and equitable under all the circumstances and that it's in the best interest of the children if there are children involved. So really the end point is that divorce judgment, that order from the judge issuing your divorce, and if there's an agreement in place, incorporating that agreement and making that agreement in order. And again, the divorce process, the court process is set up with multiple opportunities for settlement. And that's really what the court wants to see. They want to see you settle your divorce by way of an agreement. And the only time where the judge is really going to be the one deciding your divorce is in the context of a trial. And, you know, 100 times out of 100, it's best to come to an agreement and have some control over the orders in your case. Again, some cases you can't come to an agreement because one side is so unreasonable. Obviously, in that case, you have to take it to trial. But where you can come up with some kind of compromise and find common ground, an agreement is always the best route, rather than an evidentiary trial, which is not just costly, but it's risky. You never know what a judge is going to decide at the end of the day. And it also lays the likelihood of future conflict and having to come back to court on post-judgment issues, because even when your divorce is final and that you have your divorce agreement, then you have to actually enforce that agreement. And with that comes issues. And if both sides aren't on board and haven't voluntarily sort of agreed to this agreement, it's more likely than not there are going to be issues that arise, and then you're back in court on those.
Right. Yeah. So resolve your case whenever possible. Another good, like, last ditch effort before trial is to have a private mediation. So there are a number of retired judges in Connecticut who are very experienced in family law, and they are in private practice where the parties and their lawyers can book a whole day with that retired judge, where both sides can present, sort of the full history of the relationship, what they think should happen, and the judge will take the time to sit and listen to everybody and make recommendations about what they think should happen. And we do a lot of those private mediations if it's a case that's nearing trial and we really think it could and should resolve. So those can be tremendously effective in helping people reach an agreement, really feeling heard by somebody, who has a lot of experience in family court, and it helps people reach agreements in their cases. So that's an effective last ditch effort before having to have a trial, which is very sort of emotionally painful and stressful and time consuming and expensive. You're paying your lawyers to be there for days, multiple days often, if you have to have a trial. So
And
that is,
ultimately, that judge
yeah,
is coming up with orders that are really not going to be tailored to your particular case. I think you said this before on one of our podcasts that agreements, if you're entering into an agreement, you can be a surgeon. If you're going to trial, the judge is like a butcher. And it's that I think that speaks volumes. So you always want to have as much control over the language of your divorce agreement as you can. And if you're going to trial, you sort of you lose that control.
right. I would agree. So that is Nicole, is it the 1,000-foot view or the 10,000-foot view of
Like you want to ask me,
what?
Matt. I get all the sayings wrong.
Yeah, Nicole's not great with her sayings. She always botches them. I think it's 10,000-foot view. I think at the beginning of the episode I said 1,000, but I think it was the 10,000-foot view is the proper wording we are looking for here. But that is the 10,000-foot view of the divorce process here in Connecticut. So as usual, if you have any additional questions, you can contact our office. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well. So thanks for watching, and we will see you next week.